The second session of the day was entitled Cooperation to Resolution, the Great Arbitration Alliance. In this session, Professor Dato Dr. Rahmat bin Mohamad expertly moderated the discussion, while speakers including Dato Sundra Rajoo, Dr. Ismail Selim, Mr. Wilfred D. Ikatari, Ms. Jacqueline Oyuyo Githinji, and Mr. Dennis Chai all shared their valuable insights. The speakers discussed the importance of unity in promoting alternative dispute resolution proceedings and explored how digital accessibility and efficiency can enhance the arbitration process, all whilst maintaining transparency and individuality.
Welcome back, distinguished guests, ladies and gentlemen. We hope you enjoyed your lunch, and thank you all for joining us. We also like to thank 92 participants who are joining us virtually, along with all who are attending physically today. We will now move on to the second session of our event entitled Cooperation to Resolution, the Great Arbitration Alliance. With that, I would like to call upon the moderator, Professor Dato Dr. Rahmat bin Mohamad, on stage to kickstart this session. Ladies and gentlemen, please give him a round of applause. Thank you.
Assalamu alaikum. Very good afternoon. Ladies and gentlemen, this being after lunch session, but the fact that you are all here, very loyal to this, seminar, and I think that is a testament that you will stay on until the end of this session and then probably going for the gala dinner tonight. Now, before I start making the presentation, I would like to invite our distinguished speakers. First, Dato Sundra Rajoo, please come on stage. And also Mr. Dennis Chai from Hong Kong. And this session will be joined by other regional centers or arbitration centers under the auspices of AALCO, namely the Cairo Regional Centres and regional centers for International Commercial Arbitration, Lagos, and the Nairobi Centre for International Arbitration. So they will be online, and our two gentlemen here will be with us, and I think we can now start with the session. Yeah, I would like to say this, that when I was the Secretary General of AALCO in 2008 till 2016, we actually had this initiative to revitalize the importance of regional arbitration. I think the idea of having regional arbitration or commercial arbitration is very important, very significant, since in 1972 it was actually already mooted that AALCO should go into looking at commercial arbitration for both the continent, Africa and Asia. So it started with that idea, and then there was a proposal that the Kuala Lumpur Regional Arbitration Centre should be among the first to be introduced, and it was actually the government of Malaysia that had accepted that proposal, and it was in 1978 that we had the Kuala Lumpur Regional Arbitration Centre then. And on the African side, the Cairo Arbitration Centre was also being nominated, and it was proposed. And then we had Kuala Lumpur and Cairo being the African regional arbitration centers. Then later on, there are also requests from other parts of AALCO member states when we had the Lagos Arbitration Centre and also the Tehran Arbitration Centre. And it was later on, perhaps in the 2010 or 2012, when the Kenyan government requested Datuk Sundra Rajoo to assist them in how to go about in establishing another regional center for Africa. And I think Datuk Sundra had given his, a pro bono. It was a pro bono exercise. Datuk. Finally, it came into being, the Nairobi Arbitration Centre. And of course, finally, the last 2 years, during the AALCO session in Hong Kong, China announced that they will have the latest edition of the regional centers for under the auspices of AALCO. So all these arbitration centers they are all very significant. They assist not only the state government or the state members of AALCO, but the region, it serves the region need. And I think Kuala Lumpur is one that has been operating for many years. And I think this is something that the AALCO community or the Asian African community looks forward in trying to promote the importance of dispute settlement resolution through arbitration. And we hope that it will continue to prosper and to provide that important service to the community regionally and also internally. So today we have the benefit, the privilege of having all the directors except for, I think, the Tehran Regional Centres, and I will introduce the various directors of the regional centres. First, Datuk Sundra Rajoo, no need for introduction, but of course, for those of you who is not familiar with the work of Datuk Sundra Rajoo, we have been working very hard since I took up the tenureship as Secretary General in 2008. When we had the KLRCA Centre in Jalan Conley, we were actually desperately looking for a location in Kuala Lumpur, because that time the government said you have to move out from Jalan Conley, and there you are. It is actually his work that he has done this building beautifully, and all the facilities are there. I must congratulate Datuk Sundra Rajoo, and this is your second round of being directors, and I hope we will achieve more. And I think there will be the post-pandemic challenges. Yeah? And we also have my good friend from Lagos, Honorable Wilfred Ikatari.
Yes.
Welcome.
Thank you.
Welcome, Honorable Wilfred.
Thank you. Thank you.
Honorable Wilfred has a diverse background as an educationist, agriculture scientist, seasoned administrator, applied economist, solicitor and advocate of the Supreme Court of Nigeria, and also formerly commissioner and senior legislative aide, and his role as the director of the Lagos Arbitration Centre is very significant, and he has international exposure and contributes to his multidisciplinary resourcefulness. And the fourth, or the third rather, is Ms. Jacqueline Oyuyo, Githinji, Director of the Nairobi Centre for International Arbitration, and she is the position as Managing Partner at UMIZI and Director on the board of NCIA. It underscores her extensive experience of over 25 years in corporate and commercial matters. A chartered arbitrator and non-executive director, she has played a pivotal role in developing Kenya national policy on alternative dispute resolution. And Mr. Dennis Chai, Deputy Director of the AALCO Hong Kong Regional Arbitration Centre, carries a wealth of professional and academic experience in arbitration and online dispute resolution. And his role in EBRAM, International Online Dispute Resolution Centre, and Hong Kong International Arbitration Centre signify his dedication to ODR and arbitration advocacy. And finally, we have, I think, Dr. Ismail Selim from, don't worry, I will not miss you. Dr. Ismail Selim, Director of Cairo Regional Centres for International Commercial Arbitration, and with a background as a prosecutor, judge, and partner in reputable law firm, contribute a wealth of expertise to the session. As an ADR educator, also a Chartered Institute Arbitration Fellow, and consistently appointed arbitrator, his knowledge and experience extend to various ad hoc and institutional rules. Right, now we move on first to Datuk Sundra, yeah? Now, you know that given the AIAC international reach and impact, it is apparent that it has proactively implemented strategic measures to extend its presence beyond the boundaries. To gain further insight on this, could Dato explain, give specific example how AIAC has broadened its global influence?
Thank you, Prof. Rahmat, Prof. Rahmat. AIAC is actually the oldest of the sister ALCO next to Cairo. I think 1978 KL Centre was found, and then in October 1978 the Cairo Centre. So we had on two continents, two centres being formed. I believe in the first few years at that time called the Regional Centre for Arbitration Kuala Lumpur, the centre, although we had the comparatively head start to be the centre, because we started before Hong Kong or before even Singapore. I think one of the things that happened at that time, arbitration was not very well developed around the world. In fact, international commercial arbitration was nascent. It was just starting. So one of the great challenges at that time was what they call delocalization, where Judge talked about. And the idea of having a center in Asia, other than CTAC, there was no other center. So I think the idea did not catch on very clearly. The other thing is that arbitration was all located in Europe and a little bit of America, but more in Europe and particularly in the UK. So it was something new. I mean, the ALCO had the vision of doing this new delocalization and doing the centers in different continents simply because there was a cost reason that it is better to do the arbitrations, let's say, in a local place, in Asia or whatever it is, or in Africa, because many of the disputes were going to Europe. It was just too expensive. I think that was one of the main considerations. Now, after that, whether we have a strategic reach or not, it has become imperative that we need to have that. For example, in 2010, when I took over, I remember that first thing is that we had a captive market. In the sense that because we were using the UNCITRAL rules 1976 as modified by the KL, that time Regional Centre arbitration rules in the front, there was an international flavor to the centre. And I remember at that time, we used to get Government of India cases. That means union cases were coming in from government, union government cases with outside investors. It was coming to KL. It was very interesting because ALCO, being a center that was set up in India, headquartered in India, there was this natural affiliation that was going on. Now, at that point of time, in 2010, the other centers were starting to move. Governments actually understood that in order to promote trade, in order to promote investment, you need to actually foster a proper dispute resolution system. Let's say if you had an arbitral center in your place and it is working very well, it actually suggests the rule of law is there. And by that time, I think 2010, the New York Convention was really taking fire. In fact, the New York Convention was being signed by almost every trading nation. And then the ITSIC Convention was also moving, although I think there was some pullback then. So I think in 2010 onwards, I think AALCO centers had no choice but to move out. Domestic work up to a certain point you can sustain, but the center will never grow. There are a few things involved. One is, of course, the law itself has changed. So legislative change has to come in. I think in 2005, we started to follow model law. We signed the New York Convention in '84. So the two pillars were already in place. The next thing is that the center itself had to move. It had to actually come out. And again, what is the approach of moving out? Who do you move to? There is no way, I mean, in my view, for you to challenge the established centers. One of the most important things I remember at that time is to how to keep your own arbitrations first from going out. So the center had to become quite adept in providing that particular service. Then how do you attract other kinds of arbitrations that are outside to come here? The only factor that will be acceptable will be cost and a friendly ecosystem to support that. So we had to create the facilities. So I think strategy-wise, there has been a few ways of doing it. One is to tie up with the alliance and say that we have actually different understanding and arrangements with different arbitral institutions. We even work with institutions that are in different jurisdictions. So in China, we had a lot of memoranda understanding, hearing arrangements. The other thing is capacity building. The way we actually try to reach out to the world is basically organize events and courses to build capacity, not only in Malaysia, but beyond Malaysia. So you will see that at that time we were organizing events that were international in nature like this, but also we were doing a lot of domestic training. So the cadre of practitioners, there are two parts to training. One is increasing awareness, the other one is actually giving skill sets. The increasing awareness is the one that gives you the marketing reach. You have to tell outside people, especially if you're going outside, that you have these products, you have this ability, and perhaps you should come here. I think that's one way of doing it. The other way we also did was in AIAC itself, or at that time KLRCA, we internationalized the center. The first thing is that there is always a presumption that any center will only have local staff. If you are located in particular countries, but in AIAC or KLRCA at that time, we started to recruit international staff. I think that made a big difference. Moment you bring in international staff, the thinking process changes. Then there is actually a reach out for that. So I think these are some of the measures that the Prof, to say. I don't know, I can go on and on how many things, but I'll stop here.
Yeah. Thank you, Dato. Maybe you can add in, further on. Can I now invite Dr. Ismail Selim to make the presentation. Dr. Ismail Selim, representing the Cairo Regional Centre for International Commercial Arbitration. His topic shall cover the new CRCICA Arbitration Rule 2023. So let us warmly welcome Dr. Ismail Selim as he takes us on a virtual journey of arbitration insight. Dr. Selim, the digital floor is yours.
Thank you very much, Professor Dr. Dato, Dr. Rahman bin Mohamad. It's a pleasure and honor to speak in this session under your moderation and with all the distinguished speakers. It's also a great pleasure to speak again for the first time after the return of Professor Datuk Sundra Rajoo, whose achievements are known to everyone across the globe. Before discussing the new CRCICA arbitration rules, and apologies, I'm speaking slowly because I can hear the echo of my voice. Just a short presentation about the history of the CRCICA. So we have been established exactly 3 months after the establishment of KLRCA at the time. So we were established in January 1979. And since then, the CRCICA has witnessed a steady growth. At the beginning, very few cases were registered. During the first 14 years, only 42 cases were registered by CRCICA. So this means 3 cases per year in average. And this was because the Egyptian legislation that governs arbitration was not modern at that time. And starting from 1994, when the host state, Egypt, enacted a modern arbitration legislation, which was based on the UNCITRAL model law, the caseload started to grow. The caseload was international, regional, and domestic at the same time since day one. The first case that was registered by CRCICA in 1984 involved a dispute between a European company and an Egyptian public entity. And the award was rendered in favor of the European company. So this was a sign of the neutrality of the center vis-à-vis the host state, even if the respondent is a state-owned entity or a ministry. And that has been the trend until today. So it was a steady growth. It's a little bit different from KLRCA, which, to the best of my knowledge, has experienced a significant sudden growth when Professor Dr. Dato Sundra Rajoo took its helm in 2010. We administer arbitration, mediation, and we have also issued dispute board rules in 2021. And we have registered 9 cases of dispute boards since then, where we were requested to appoint dispute board members. Until today, we have administered more than 1,650 cases. Likewise, the Asian International Arbitration Centre, our arbitration rules were always based on the UNCITRAL arbitration rules of 1976 and 2010 respectively. And this, you can see it, this is an example on the screen of Article 17, Paragraph 6 of the CRCICA Arbitration Rules of 2011, if you compare it with Article 17, Paragraph 5 of the UNCITRAL Rules of 2010, you will find that the two articles are identical. But during the last decade, international institutional arbitration has witnessed a lot of developments. So we could not continue anymore by simply adopting rules that are identical to the UNCITRAL rules. We have decided, likewise, most of the prominent institutions worldwide to depart from the UNCITRAL rules where necessary in order to respond to the needs of the users of institutional arbitration. So if we follow to the next slide, please turn the slide, you will see that the new CRCICA arbitration rules are still based on the UNCITRAL arbitration rules. So the new rules still leave a wide room for party autonomy and maintain the flexibility of the UNCITRAL arbitration rules, but are now more robust in their content. These rules have been drafted by a committee of very prominent senior arbitration practitioners and have been reviewed by the CRCICA Advisory Committee and the CRCICA Board of Trustees. And we have also consulted our users, and we have received very interesting comments, and we are going to follow some of these comments and proposals. So the draft that is now on our website will most likely be slightly amended. And we expect to issue our new rules by October or November 2023. So the new arbitration rules have also been inspired by the transparency rules of the UNCITRAL, which have been issued in 2013. They have also been inspired by the UNCITRAL expedited rules of 2021, but with some modifications that we believe that are more suitable for institutional arbitration. We have also, during the drafting process of our new rules, we have thoroughly reviewed the rules of around 15 major arbitration institutions. We have made a very thorough comparative study. We have read the guides that have been issued by several institutions. We have also relied on our own experience, and we have identified the problems and the challenges that we have faced when we were applying our 2011 rules. Because we also have our own needs and our own culture, I would say, the culture of our ecosystem, that are a necessity to be complied with. The new rules originally comprises 5 sections. These are the existing rules of 2011, whilst the new rules will comprise 6 sections with 56 articles and 4 annexes. When you will read the new rules, and when the user will read our new rules, he or she will not feel that it is a new center. The spirit and the content of the old rules are still there, but just the user will feel that there has been an upgrade and an improvement of the existing rules. And this is best practice. When you renew your rules, the user should not feel that it is a new center. The user shall feel and get the impression that it is the same arbitration center, but has improved its rules. So if we will see at the next slide, some of the provisions that never existed in the old rules of 2011 because they never existed in the UNCITRAL 2010 rules. But they are a necessity for the user of institutional arbitration. I will name 4 other provisions under Section 6 of the new rules. Article 15, which governs the consolidation of parallel arbitrations filed at the center, the Cairo Regional Centre. Multiple contracts, so a single arbitration that has been filed based on multiple contracts. The early dismissal of claims if they are manifestly without merit. And the obligation to disclose the existence of a third-party funding. At the next slide, we also discussed the 2 new annexes that did not exist in the 2011 CRCICA rules because they did not exist in the UNCITRAL 2010 rules. Annex 2, the emergency arbitrator rules, and Annex 3, the expedited arbitration rules, which have only been adopted by the UNCITRAL in 2021. The bylaws of the advisory committee of the center existed before, but they were not part of the rules. So we have included them as an Annex 4 to our rules. Regarding Annex 1, which is the table of the administrative fees of the center and the fees of the arbitral tribunal, they form part of Annex 1. And we will see that because of the inflation and the development of the economy, not only in Egypt, but around the world, the administrative fees of the center have been increased while remaining cost effective, as mentioned by Professor Datuk Sundra Rajoo. So still arbitration in Asia and Africa would still be cost effective because this is one of the intention of the establishment of our centers. But so there is a balance between maintaining the cost effectiveness of the institution and the remuneration of the arbitrators, and to be able to provide an adequate service to the users. So the arbitrators also must be well paid according to a scale that varies between a minimum and an average and a maximum and the spectrum in between. And the fees will remain determined on an ad valorem basis, which is linked to the amount in dispute. And this is one of the 2 major ways of determining the fees of the arbitrators. So I will give an example. For the amount in disputes which are less than 1 million USD, the arbitration costs are still almost the same with a minor increase. However, for value cases, we given the example of a $20 million sum in dispute, the fees of the arbitral tribunal would vary between 111,000 as a minimum US dollars, 305,000 USD in average, if we apply the average scale of fees, and 500,000 US dollars if we apply the maximum scale of fees. This is if the tribunal is composed of 3 arbitrators or more. And you see the comparison with the old rules in black. So there is an increase compared to the old rules that varies respectively. It's around 16% or 12% or 12%, 0.8 respectively. Did I increase my time limit?
You
So
can
the distinguished
perhaps,
moderator will me to stop me.
perhaps you can add on later before I, call another. Is that okay with you?
Yes, I think I have mentioned most of the most important
Right.
features of the news.
Thank you, Dr. Ismail Selim. Thank you very much.
You're welcome.
Ladies and gentlemen, it is also my pleasure to introduce our next speaker, Honorable Wilfred Ikatari, representing the Regional Centre for International Commercial Arbitration, Lagos. Honorable Wilfred, would you like to start your presentation?
Thank you, sir. First of all, happy to see you, my very Secretary General that when I came on board, became my very good friend and remains my friend. I'm very grateful. I greet all of you, my fellow directors and participants. To begin with, we have to look at the theme of what brought us together in this arbitration week. And it is that we are talking of cooperation to resolution, the Great Arbitration Alliance. Then the question is, what is this Great Arbitration Alliance? I think looking at it at the larger scope, I think it is an alliance between two continents of Asia and Africa, with abundant resources and demographic dynamics. We share similar economic conditions, which AALCO, our parent body, understand and appreciate that there is a need for an alliance in order to take advantage of our conspicuousness in terms of the global demographic and economic status. It was earlier realized that arbitration, as rightly explained by my friend Director Professor Rajoo, all arbitrations on the continent of Asia and Africa are focused and shift from the continent to the old traditional institutions, which basically are private arbitral institutions. It's like the African and the Asian countries and nationalities promote to our own disadvantage. So AALCO now see it that for us to play a relevant role and sustain our own economic growth and commercial business concern, either national or across border, there is the need to build a mechanism through a policy dedicated towards realizing the need to establish a dispute resolution scheme. And I think that is a novel idea at that time, given the condition and circumstances of that period. And you look at this second level of the Grand Alliance, is the alliance between nations that constituted AALCO on the continent of Africa and Asia. Then at the next level is the alliance between the arbitral institutions that were brought in place under the policy arbitration resolution mechanism of the Asian African Legal Consultative Organization. Principally, that one led to the establishment of the regional centers. And definitely, the Malaysians were very fast, and they come first to the first arbitral institution, followed by our brothers Egypt, and then Lagos. Thereafter, Tehran came on board, and now we talk of Cairo and Hong Kong. These institutions were not formed as national entities or intended to act on national basis, but was formed as institutions that are clothed with international juridical personality recognized under public international law. Those agreements, which is the headquarters agreement that established these institutions, remains under public international law a treaty which makes each of the centers as a legally recognized personality to act in the economic and commercial fields, regionally and globally. And in that respect, these functional arbitral institutions were made unique arbitral institution in the global family of arbitral institutions, as they are public, regional, non-profit oriented institution of international character and global recognition. The same constitutive documents floated with my regional center, like others, with the ability and capacity to function and act in the economic and commercial fields as international legal, distinct from the host state. That is, in my own case, Nigeria, and other member states, with attendant rights and obligations, and including ability to maintain international claims, enforce and defend its right under public international law. If you look at it from that perspective, you understand that these centers are created with powers and functions to promote arbitration, coordinate and assist other arbitral institutions in the regions, undertake the assistance to arbitration, ad hoc arbitration, and also conduct institutional arbitration. Further to that, they are even empowered to assist to enforce awards. In other words, if any member state or any other body register an award with the institution under their powers, they can assist to enforce it. they are also empowered to ensure that their own awards, they can go ahead and enforce. So they are not built on the basis of acting as an element of where it is subject to the territory of where it is hosted. No, 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 no. It cannot be that way. And that is why our power to adopt with institutional features the ancestral model rule, and of course, in the local legislative order, they bring in the ancestral model law, like Nigeria recently done. Of course, they have done it earlier. So our operations are based on international legal instruments or conventions, like ancestral rules, ancestral laws, and conventions, you know. So for us in the center, I come on board and I inherit the 1st of July 2008 revised draft rules of 1999 based on the United Nations Commission on International Law, Trade Law, Arbitration Rules adopted by United Nations Assembly in 1976. The modification introduced to add institutional features to the revised rules of 2008 were carefully crafted to take care of the future modernization of the rules of arbitration, and that sustained the center rule till the current version in 2019. In fact, I commend them when they were revising those rules. While most of our sister regional institutions have gone further to revise so many times, that of the center stood very clearly. And as a judge, I read these rules not from the perspective of advocacy, but I read the rules as a former judge of an investment tribunal with the capacity to interpret and apply the rules as they are. So when we constituted the board to review these rules, it is my understanding that the rules were able to stand the test of time because of the futuristic manner in which those institutional features were put in place. However, by our revised rules, which come in effect into 3rd October 2019, we draw it from the ad hoc rules of the ancestral. And in doing so, we intended to accommodate the diverse culture, legal system, and jurisdictions globally. And parties can adopt as appropriate for ad hoc proceeding at the center. The center unique status in the global arbitration institution family, under the rules, the transparency investor-state arbitration, including rules on international convention and mediation agreements, were taken into consideration.
Honorable Ikatari,
yes,
you have exceeded your time. Could you like to sum up in 1 minute?
So,
yes.
By way of summary, our operation to solution is to ensure that we, the arbitration institutions on both continents, come together in a form that will be a collective advantage and win-win situation to all those of us in the arbitration spectrum under the prism of arbitration. And I think that is why this arbitration week is well crafted. And we appreciate and will continue to do so, and will continue to contribute to the development of arbitration to attract further investment on both continents. Thank you, sir.
Thank you. Thank you very much, Honorable Ikatari, for sharing your insightful perspective. Thank you. May I now move on to the fourth speaker, Ms. Jacqueline Githinji, representing the Nairobi Centre for International Arbitration. Ms. Githinji's experience and expertise promise to enrich our perspective on arbitration in the African context. Please, Ms. Jacqueline, you have the digital floor.
Thank you very much, and thank you to everybody who is present virtually or in person. It would have been nice to join you in person, but this makes for a good option. So like Dr. Selim said, I can also hear my echo, so I will be pausing every so often to allow the voice to settle. All right, so I'm very grateful to the speakers who have spoken in advance of me, because they have set the stage for the two issues I want to bring out in my presentation today. So allow me firstly to introduce the Nairobi Centre for International Arbitration. As has rightly been said, we have common roots in the AALCO, and we were established by an Act of Parliament in the year of 2013. With, like the rest of the centers, the mandate of promoting international commercial arbitration and other dispute resolution processes. And to that extent, then we have published our own rules, both in terms of mediation and arbitration, currently working on a set of rules for adjudication. And with that in mind, then we also have established 4 panels of dispute resolvers. So we have an international arbitration panel, domestic arbitration panel, an international mediation panel, and a domestic mediation panel. I do hope that several of you are already on those panels. Next slide, please. So our mandate can broadly be divided into 4 thematic areas, which is really strategic. Jointly with other agencies, we are working on a national policy on ADR. And the reason for this is just to really perhaps echo what previous speakers have said around building awareness on ADR and arbitration and promoting those forms of dispute resolution. And perhaps bringing some sanity to certain aspects of dispute resolution that are less, let me say, regulated in quotes, but not without being too prescriptive, perhaps in the area of mediation, giving some general guidelines in terms of how mediation centers can continue to ensure that the professionals they are churning out into the public are actually a safe pair of hands. In terms of operations, obviously, we continue to promote, facilitate, and administer disputes in the manner that I have already mentioned. And for that reason, then constantly training and accrediting dispute resolvers and ensuring that we are up to date in terms of emerging issues or indeed current issues that require in-depth conversations. So coupled with that, the whole advocacy and capacity building, and I'm sure all the centers can relate with this, not just educating the public, but also our own teams internally to enable then the center be a proactive center in terms of administering disputes as well. Moving on then to the topics of this day. I keep wanting to say morning because it's morning in Nairobi. So deepening the integration under the AFCFTA. And I believe this provides an opportunity to take forward the conversation that my senior brothers on the continent have already indicated around broadening and deepening the collaboration within the AALCO to delve into the opportunities availed by the agreement. So for those perhaps who may not be familiar with the agreement, this is the African Continental Free Trade Area Agreement. which was signed on the 30th of May 2019. It applies to all the 54 members of the African Union, and currently 46 of those nations have ratified the agreement. The whole idea behind the agreement is to provide for regional economic integration, perhaps removing or eliminating barriers to trade within the continent, reducing barriers or indeed eliminating barriers for up to 97% of goods and services, and in that way then stimulating intra-African trade. I think those of you who have traveled to Africa have perhaps observed how even intra-African travel is sometimes incapacitated by the kinds of trade routes that we have developed over time. So perhaps to visit my brother in Nigeria, I may have to stop over in Dubai or even in Europe, which makes for very interesting travel arrangements within the African continent. So this agreement really is to help us as a continent see the capacity that we hold to trade with each other, but perhaps also more relevant to this conversation, how as a bloc, we can continue to trade externally. With a population of 1.3 billion, a combined GDP of close to 3.4 trillion US dollars, obviously this provides numerous opportunities for this Afro-Asian collaboration. The whole idea is to boost the collective African income to 450 billion USD by the year 2035. So there is an opportunity then through the agreement to offer efficiency, credibility, and effectiveness of not just our trade opportunities, but because we know that dispute resolution follows commerce, then how we as arbitral institutions can tap into the dispute resolution mechanisms envisioned under the agreement. So if I can then just quickly talk about that on the next slide. There is an investment chapter in the agreement, but more importantly for us as dispute resolvers, there is an established protocol on the rules and procedures on the settlement of dispute. Fairly easy read for those of you who'd like to delve into it with more depth, perhaps after this arbitration week. But the three key takeaways are really the centrality of arbitration as a dispute resolution mechanism. The scope really is around disputes arising from the agreement. So useful also to understand the agreement as a whole. And then the various bodies established within the protocol tasked with dispute resolution. So firstly, there's the dispute settlement body, which is established under Article 5. A dispute settlement panel, which is established under Articles 9 to 19. And an appellate body established under Articles 20 to 24. Without going into too much detail, it is important to underscore that the dispute resolution protocol understands the needs that we already appreciate as dispute resolvers around privacy, party autonomy, neutrality, efficiency, finality, confidentiality, and of course, the enforcement of the awards that will arise from the protocol. So already as dispute resolvers, as arbitral institutions promoting arbitration, we are very well placed to provide technical capacity under this protocol, to perhaps form the panels that are considered under the protocol. And of course, the whole concept of party autonomy means that as a precursor to arbitration, then there has to be consent to the arbitration. Parties are free to choose. So just to emphasize, the protocol doesn't determine who the parties will select as an arbitrator, or indeed what rules they will apply to their arbitration. So that whole aspect of party autonomy is fully explored in the protocol. And prior to this, then the parties are encouraged to consider local remedies. So in much the same way that you are familiar with let me say, multi-tier arbitral clauses, the protocol actually encourages goodwill efforts, best efforts as the protocol says, negotiation between the parties, and then arbitration as a final resolution in the event of ability to close. So with that in mind, where are the opportunities for collaboration as arbitral institutions? I think firstly, and it has been underscored, we are supposed to be exchanging knowledge within the AALCO. To what extent are we doing that? To what extent are we enabling best practices, case studies, insights to enrich our overall expertise? To what extent is there opportunity to harmonize some of our rules to accommodate our different legal systems, our different processes? To what extent are we building capacity? Yes, this is a good start, and I do hope that we can continue these sort of conversations. And to what extent are we able to provide technical support to each other? Resource sharing platforms, access to legal databases, precedents, research materials. These are also critical to any arbitral institution. So the manner in which we continue to engage, the manner in which we continue to work together as brothers and sisters, I think will enable us stand the test of time, as has already been alluded to by the previous speakers. There is an increasing threat, if I may say that, of the older non-AALCO institutions starting to see the progress of our local institutions or our AALCO institutions and trying to claw back. So how do we continue to withstand those threats? On the next slide then, this continued conversation around collaboration, this mutual understanding that we have, how do we continue to exploit? How do we continue to understand that our nations, the Afro-Asian nations, are in constant trade? And how do we harness, both through the AFCFTA and our own arbitration rules and procedures, and make us the forefront in terms of choice of arbitral panels, arbitral processes, administered arbitration. So let us continue to have this conversation around how we can drive each other forward to ensure that we're not left behind in these conversations. I'm conscious of the time available, so let me then talk about the second aspect of collaboration that's possible for us as AALCO institutions. It's not lost on us that there's a global digital transformation, revolutionizing not just dispute resolution, but trade and commerce. So on the next 4 slides, perhaps I can talk a little bit more about this and consider how we may collaborate as arbitral institutions. The pandemic certainly provided an opportunity for us to explore how we operate as dispute resolvers, as arbitral institutions, as users of arbitral processes. So with that, we saw, for example, we dipped our toe into the waters of digitalization. So we embraced virtual hearings. Many of us have signed the Green Pledge, and we continue then to consider how submissions are made to tribunals in terms of document management systems. And with this technology comes risk. And I want to challenge us all and suggest that the best risk management is at the point of design and planning. So again, perhaps an opportunity for us to consider how to collaborate in the design and planning of our platforms or digital processes in arbitration, but also how we can capacitate our dispute resolvers to embrace technology in dispute resolution. Of course, virtual hearings enable virtual venue, virtual hearing of witnesses, resolving of technical issues, exchange of documents, and on the flip side of that coin, considering data privacy, cybersecurity, all balanced against efficiency and costs. Also, new disputes arising from new ways of commerce. Many of you are familiar with the metaverse, which in the simplest form of description is a 3D internet. You can have experiences that are virtual, You can indeed have trade that is virtual. I think luxury goods are perhaps the brands that have been at the forefront of the metaverse transactions. So in Asia, I'm sure you've seen this a lot more than we're seeing it in Africa. So what are some of the challenges that are starting to arise in terms of disputes arising from commerce in this area? Back to the challenge of adaptation, which is on the next slide. What is our level of technological literacy? How are we dealing with cybersecurity? How do you, as an arbitrator, confirm to yourself and give yourself a level of confidence that the parties in your virtual room are the parties who must be in the room, that there's no level of coaching from counsel who may be advising the users of your arbitral process, how are witnesses being secured? How do you know that your witness is indeed a human witness and not an AI-generated witness? These are concerns that we're going to continue to address going forward. Some of the disputes that may arise from this will include biometric data, how it is secured, how it is managed, what are the contractual and commercial liability issues arising. So lots for us to focus on as arbitral institutions as we go forward in these conversations. I think recently there was an ex-Google executive who sounded a warning bell on the adoption of AI, for example. Is there unchecked intelligence, and in whose interest? We may not be at the forefront of developing those technologies, but we certainly need to be proactive in terms of listening in on the conversations and understanding how they may impact disputes and commerce. On the last two slides then, perhaps some opportunities for us to engage in education and training, as I've already mentioned, how we're equipping both legal practitioners and dispute resolvers in terms of digital skills and knowledge. And I want to underscore this next one. Where is there opportunity to collaborate in terms of platform development? Should we all then just be developing our own platforms without considering perhaps the synergies that we can leverage on under the AALCO umbrella? What regulatory frameworks do we need to consider in the era of digital arbitration, or digital dispute resolution within our member countries? What opportunities exist for collaboration and exchange, best practices exchange, understanding the digital impact of the transformation in trade and commerce? So allow me then to close just by inviting us all to consider how we respond as AALCO institutions. It will necessarily be a proactive adoption, adaptation, considering where there's convergence of our digital transformation dispute resolution processes, and considering how to take our institutions through the 21st century and beyond. Allow me then to close on that note, and happy to take any questions or comments once it's open to the floor.
Thank you, Ms. Oyuyo, for the most comprehensive presentation. I was told how much time we have. 5 minutes? So sorry, Dennis, that you only have 5 minutes. 5 minutes, that's all? Okay, let's have your view on this. Thank you.
Thank you very much. Indeed, I prepare a presentation, but of course, instead of running the slides by slides, I will just share briefly. Actually, I took some notes with my pad just to share. First of all, let me thank you for the organizing this wonderful event, which is a well-chosen topic, well-chosen theme for discussion. But for me, I would like to share some of my experience, maybe some story when engaging my career in the dispute resolution. I started my career at HKRAC since 2004. So this year marked almost 20 years of my career in dispute resolution and arbitration. And I was also in HKRAC handled domain name disputes. And I was also the Secretary General of the Asian Domain Name Dispute Resolution Center, and also a board member now. And Dr. Dato Sundra Rajoo was the chairman of the ADR DRC when I was a Secretary General and board member. And I have been promoting ODR, the technology, for traditional arbitration for many years. Of course, I have to admit that I received very less success in that regards, because until the COVID-19 comes, the whole world said we are now doing online dispute resolution. So the COVID-19 indeed helped accelerate the use of online dispute resolution. So even though I have been promoting that for many years, but of course not very successful until COVID-19. So COVID-19 has changed everybody's practice in terms of dispute resolution. And what else is, I have been rethinking what is the definition of ODR, because people just using Zoom and maybe in mainland China, Tencent meeting, this kind of, we call it as consumer grade technology for arbitration, which is confidential in nature for arbitration. But you have no control of the data transmission in behind. So what happened was when I was engaged in a government-funded project in Hong Kong called eBram to develop our Hong Kong's capability to do a more secure online platform, which is a professional grade, not consumer grade. We have tailor-made technology for arbitration hearing. We make sure the platform or the technology is based in Hong Kong. We have control of the data transmission and storage. So that's make things different. So that's why ODR is a mega trend. We have to embrace it, even though I understand that many of you still prefer in-person meeting. I like in-person meeting as well, but we can go mix. So my second story to talk is why we need to have a new center, a new AALCO center in Hong Kong. There's so many arbitration centers now. Why we need to add one to Hong Kong? Do you know how many arbitration centers in Hong Kong? Any idea? 1, 2, 3, at least one, or maybe more than one? I can tell you in total 7. But I won't tell you I won't tell you in the detail. You can Google it and you can find all these arbitration centers. Why we need to add one more AALCO Hong Kong Regional Arbitration Centre? What are the reasons? What are the benefits for doing that? And I would just want to share another story in my time at HKRAC. And I have read a lot of reports. One of the reports labeled Hong Kong Arbitration Institution as Chinese Arbitration Institution. Politically right, they're very correct. So that means that in terms of the neutrality of arbitration center, that could be a question mark. People would prefer an arbitration center which is neutral and independent to both parties in dispute. So Hong Kong is very special. We have the Court of Final Appeal. We are running different legal system which is based on common law. But these are not been mentioned in that report. So with AALCO Hong Kong Regional Arbitration Centre comes, that marks the history. This is the first and only one international governmental body status arbitration institution launched in Hong Kong. So this makes things different. As a lawyer advising your clients, you may have a different strategy for proposing arbitration centers as a dispute resolution center. So these are the benefits of an AALCO center. All the 6 AALCO centers share this kind of unique benefit. You can get it. You can't get it from other places. So AALCO Center indeed is very successful demonstration of the great arbitration alliance, which is addressed the theme here. And we can sort of, the third story I would like to suggest is how we enhance the collaboration between or among arbitration institutions in within the AALCO framework. I have learned a lot from our fellow speaker, which mentioned a lot of great points for collaboration. And it is a matter of fact that the whole world's arbitration centers keep signing MOUs, right? It's good to sign and take picture, but what they are doing is only limited to, most of them are limited to organizing joint events. But there are another level of higher collaboration, as Dr. Sundra Rajoo mentioned. We can provide mutual assistance in very detailed arbitral proceeding, the witness recommendation or the expert recommendation. This kind of more things can be done. And in terms of enforcement of awards and arbitral direction, interim measures, these kind of more substantive, more deep collaboration can be more easily being carried out within AALCO framework. So these are my very brief suggestions. I hope I can keep my time. Thank you very much.
Excellent. Thank you very much for keeping time, Dennis. So I think, unfortunately, we cannot entertain questions from the floor or online because they are very strict, these people. So, so thank you so much. And on behalf of the participants, we would like to thank the distinguished speakers for making their presentation. Those are very valuable input, and we hope we would have a better understanding and also to promote the so-called global alliance among regional arbitration centers under the auspices of AALCO. With that, ladies and gentlemen, I thank you.
Thank you to our panel of speakers and moderator for the insightful session. Thank you, Mr. Denschai, for keeping your speech well within time. I'd like to give our special thanks to Dr. Ismail, Dr. Wilfred, and Ms. Jacqueline, who have taken their time to be with us virtually. I'd like to see you here physically at a future event. Thank you. Now, may I please request the panel to remain on stage, and would like to invite our Assistant Director of the AIAC, Mr. Danish Chandran, to come up on stage and present a token of appreciation to our panel. Thank you to our panel.